The following episode was originally recorded for a private podcast as part of the Equipped for Life course. It has been edited for public release, but may reference training material from the Equipped for Life course. All right, so we want to talk today about a growing segment of people, from my perspective, who are generally coming from the extreme left side of the political spectrum, who are defending free speech violations as long as those violations aren't made by the government. So Tim is here, and we've got Rachel on the line, but we also wanted to bring on an expert who spent a lot more time engaging these arguments. So let me spend just a few minutes introducing our special guest, who just recently joined the Board of Advisors at Equal Rights Institute. Casey Mattox serves as Senior Counsel and the Director of the Center for Academic Freedom with Alliance Defending Freedom. When Mattox first joined ADF in 2009, he participated in litigation and later focused on working with allied attorneys to litigate cases to protect the rights of Christian students, faculty, and staff at public colleges and universities across the nation. In 2011, Mattox was eager to put an end to the evil of abortion and joined the Center for Life. As senior counsel, he has been active in defending the sanctity of life and holding the abortion industry accountable for its fraudulent use of taxpayer dollars. He is also active in defending the freedom of conscience of healthcare workers. Mattox earned his JD from Boston College Law School in 2001. He's a member of the bar in Virginia, the U.S. Supreme Court, the U.S. Court of Appeals for the 7th, 9th, and D.C. circuits, and the U.S. District Courts for the Eastern and Western Districts of Virginia, the Northern District of Florida, and the Eastern District of Michigan. Casey, thanks so much for joining us today. We have lots of questions for you.
Well, thank you. I appreciate it. You know, I always say that my bio is quite long. The short answer basically is I sue schools. That's what I do.
There you go.
So that's the much shorter version is I'm responsible for suing public universities when they violate the First Amendment. That happens all the time.
And we very much appreciate that.
That is an excellent service to humanity.
Okay, so I'm going to just start throwing out some things that I've seen people generally on the left say when they're making these kinds of arguments against free speech. Some of these are taken from under a blog post that we did talking about cases where we've seen people censure pro-life activity. None of these talking about like the government coming in and censoring us, but more what people have done, like with big noisemakers and sheets and things like that to try to disrupt free speech. And so I'm sure you've heard comments like these. I just want to get your take and kind of responses to these. So one of them here was someone who said, the idea of free speech comes from the First Amendment. Congress shall make no law, etc. This means that as an American, you have a right to say and believe anything you want without being penalized by the government. Basically, you can't be killed or imprisoned for expressing a political opinion, religious belief, or for reporting on the news. And you also have a right to peaceably assemble. Nowhere does it state that you have a right to be heard. So I see this a lot, and I almost wonder, like, have conservatives sometimes done a bad job of sometimes invoking the First Amendment when we've had free speech problems? Is that a thing that we need to get better at being careful of? How would you respond to someone who's talking about this?
Sure. Well, as a first principle, the idea that the idea of free speech comes from the First Amendment is just not correct. The Constitution, First Amendment included, it codifies, protects pre-existing rights of individuals, and so. You know, it doesn't positively create a brand new right in the First Amendment. That's that the founding fathers knew that they had a free speech rights that were inherent, and that's why they fought a revolution in part and wanted to make sure that that those rights were written down and documented. So it doesn't come from the First Amendment. But I think the broader point is that there is a cultural problem here, that you have a kind of a breakdown in respect for appreciation for hearing other ideas and engaging in civil communication, and instead the idea is you see opposing views treated as an obstacle, as a problem. And so, you know, while from a legal standpoint, yes, it's very rare, going to be very difficult to actually do something against individuals in many cases who are preventing people from speaking because of their own disruptive activity. That may be the case. You can't do what we can do when a university or the government is actually violating your First Amendment rights, which is to sue. But that doesn't mean that kind of the pre-existing respect for people's free speech didn't exist. And so the First Amendment is something that just expresses that the government is not going to violate that, but that doesn't mean that we did not have a cultural understanding, and we should not have a cultural understanding that dialogue is better than the sort of intimidation tactics we're seeing right now.
I want to get you talking about the heckler's veto a little bit, because I feel like a lot of times the comments that I'm seeing online, like it really comes down to this. So this is a quick quotation from, again, a leftist that was on our blog. He said, "You have just as much free speech rights as your fellow citizens. If you go to a public area to express your free speech rights, but get drowned out by someone else expressing their free speech rights, you don't get to shut down someone else's rights because you want to be heard."
Yeah, I mean, there's really kind of two questions. There's the question of what are your rights? Now, if they have the ability to speak in the same area, they're going to be able to do that, and that's going to be something we have to deal with. There is a danger, I think, in sort of a reaction against the people who are trying to shut down our speech. There is a danger in a reaction that says, let's punish them for trying to shut down our speech. While I understand the frustration, and frankly, I think we have to persuade them, which may be an incredibly difficult task, that hearing opposing views and dialoguing with us is going to be better than the current path they're on. But I think there is a danger, particularly for the pro-life movement, in trying to punish people who are, quote, disrupting our speech. Because frankly, I think that the people who are most likely to fall prey to such a rule, right? So if we imagine we actually had a university policy or a government policy that said anyone's speech that disrupts or prevents another person from speaking or interferes with someone else's exercise of First Amendment rights, the way that actually plays out on a university campus, I fear, is that you're going to have the government looking the other way when that situation happens to the pro-life students when they're being drowned out by someone else. Mm-hmm. And then when the pro-life students are standing 100 yards away and Cecile Richards is speaking, and they're standing there and they're peacefully handing out literature, that you're going to have university administrators walking by and telling them, hey, I just wanted to remind you that we have a policy that says that if you disrupt this, then we have a mandatory punishment. That's, I think the bottom line is you can, if the problem is, and it is, that you have left-wing administrators on university campuses that are hell-bent on shutting down conservative speech, or at least, skewed that direction, we're not going to stop that by giving them more power. So that's my concern, I think, is that I think we have to sort of play through this as a pro-life movement and learn how to dialogue better. We can't use the tools of government so much to try to stop people from objecting to what we're saying.
So Casey, I want to hear from you what you would suggest students do if that situation is happening. If a Students for Life group would set up a very peaceful polling table, they're trying to do dialogue, and then students come out with noisemakers and blowhorns and are shouting and trying to stop a dialogue event from happening. What should students do in response to that when they're really being drowned out and this other person isn't listening, even to our attempts to de-escalate the situation?
Right. So first of all, I think, very often what I'm talking about really is more like new policies. Some of the calls that I've seen for new rules that would say, if you disrupt someone else's expression, then you're subject to an automatic punishment of, X number of days suspension, and the second time you're expelled from school or something like that. Those kinds of brand new mandatory punishments of people for disruption, I think are a concern. But just about every school and every government has laws that are already in place that should prevent at least the worst kinds of these situations. So first of all, if you have a permit, if it's a permitting situation, you've already reserved a space, then that comes with certain rights, right? You have an ability to be in that space, and other people don't have an ability to be in that space at that time for their event. So, you can call on the school, look, school or the government or whoever it is, you need to fix this because we have reserved this space, and these folks are disrupting that. So, when you have, for example, Ben Shapiro and speakers like that, and this is going to happen with pro-life speakers as well. Mm-hmm. You've reserved a meeting space. You've reserved, a lecture hall. You have your speaker coming. They shut the person down. You have recourse there because the school will already have policies that say you can't disrupt an event like that. So I think there already are some things like that now from a practical standpoint. I think I think we have to think, or it's going to be beneficial to try to think more in terms of how can we depict our message in ways that can't be shouted down. I think we need to come up with more graphics, with more ways of communicating visually, so that people are able to see what we're saying, even if people are going to try to not allow us to be heard. But usually there are going to be ways that you can already deal with existing laws, and maybe that's the big takeaway. Know what those are. What are the provisions that say, look, this is the decibel level, for example, above which, if you're above this level, you are disrupting the peace, and the police can do something about that. And then bring a detector that will allow you to be able to show the police, look, they're above 100 decibels. And here's proof of that. And according to this ordinance, they need to be stopped. So I think it's know the existing laws, but also look at ways that you can communicate in ways that can't be shouted down.
Can you talk a little bit about the concept of a heckler's veto? This is something I've heard, I think, in every single ADF presentation I've watched in kind of response to sometimes what people have said about like the Ben Shapiro event, which is like, hey, we're using our free speech to shut down this event, and that's fine. Can you talk a little bit about that concept?
Sure. Yeah. I mean, the idea of a heckler's veto is basically that the government will say, schools particularly will say, because other people are objecting to your speech and that's creating problems, then we're going to stop you from speaking. And so that basically creates a situation then where it's a race to the bottom. Whoever can be the most disruptive wins. And that's, and unfortunately that is what we're seeing in a lot of campuses right now. It's basically a question of how do you deal with that problem. It's not I'm not ignoring the problem. I just don't want to make it any worse than it already is. So, but I think it is a major issue. Courts have routinely said that it is unconstitutional to prevent a speaker from speaking because of the objection of someone else, because that's essentially a viewpoint discrimination, right? Because of other people's views, you're being discriminated against for your speech. And it runs counter to the entire idea, particularly of a university environment where different views are supposed to be heard. It runs counter to that entire idea. Anyway, it's unconstitutional, but it's something that, particularly when you see some of the violent tactics that are being employed on some campuses, it's difficult for police to figure out exactly how do you deal with these situations where, perfectly rational conversation is causing people to legitimately become violent.
So at a practical level, what should a student do if they're encountering activity like let's say the noisemaker example? They're trying to host a dialogue event. They've got a pool table. They're trying to have conversations, and the pro-choice club comes over with noisemakers to drown that out. Let's say then the club president goes to the university, and the university says, hey, this doesn't seem like that big a deal to us. This kind of seems like free speech, dog eat dog out there, and they don't want to do anything. Is that the time when the student needs to call someone who basically for a career sues schools?
Yeah, that is, yes. And particularly so that's where I think on the front side you want to try to think, okay, if people do this, what's the best position I can put myself in? And if we're going to reserve an area and we have exclusive use of that area for our event, that helps, right? Because now you can rely on that. Know what the rules are that say, if you disruption on campus or whatever the policies are that the school already has in place, so that you're not trying to figure those out before your event, because you can almost sort of forecast right now that you're going to have these issues. But then as it comes up, you call on the school to actually enforce its policies. And if the school declines to do so, or in some cases has actually even more actively participated in trying to stop expression from happening. I mean, the Cal State Los Angeles situation with Ben Shapiro, you actually had professors calling or putting out the call and then going and joining other professors or other students to physically block access to the building. So it's not just failing to enforce, it's actually actively participating, which is the other thing too. Record what you're seeing, record what's happening. So make sure you bring in an iPhone with sufficient charge, and you can record, exactly what's playing out, because frankly, in many cases, not only is it the ridiculousness that needs to be known to the rest of the world so people have an understanding of what's really happening, but it also allows you to document things like, and this is a professor who's standing there engaging in this.
Right.
These are the administrators who are standing there doing nothing, so that it's actually documented.
Yeah. Let me ask another question. My impression is that First Amendment isn't ambiguous on whether or not a group of protesters can physically blockade people from going to a Ben Shapiro speaking event at a public university. Like clearly they can't they can't do that, and I'm assuming they lost any lawsuit that happened there. Why is there still stuff happening? Like, are the penalties not big enough?
I think so first of all, I think, one of the arguments in the Ben Shapiro case, the school eventually ended up changing its policies, but one of the problems with the Ben Shapiro case is that was exactly their argument. Look, we're engaging in expression too, in blocking you. Well, the First Amendment does not protect your ability to physically block access to something. That's not how that works, right? But that is a frequent refrain that we get from schools. The other problem we see is that, with many of these universities, and the schools do try to distance look, that's other people not covered by the First Amendment are acting, it's not us. And so there's this problem of, when can you hold the school responsible for other people acting, and the school will try to act like it's not really responsible. It has the ability to enforce policies, but isn't mandated to. So those sorts of arguments will play out. But the big problem, I think, ultimately, is that these universities know that when they're sued, it's taxpayers that are footing the bill. And
That's frustrating.
So it's all of us who foot the bill, either because the Attorney General's office defends the school, or because a law firm somewhere that they can hire will be paid by taxpayers. And so if you have a particularly ideologically driven argument, then sometimes there is benefit to the school in just trying to play this thing out and run with it as long as they can. They're seen in some quarters as being on the side of the angels if they're prohibiting certain kinds of speech. And so that's kind of the problem we face. We obviously provide our services for free. We're a nonprofit legal organization and don't charge our clients, but unfortunately, we're all paying for the schools on the other side to be defended.
Is there any kind of bigger picture path forward at a legal level to try to get around this problem, a way that could actually cause public universities to be penalized in a way that incentivizes them enough to actually follow the law and not just take the slap on the wrist when they feel like it's worth a slap on the wrist?
Yes, at least in some cases, when the law is clearly established, so that no reasonable government official would have thought that what they were doing was right, then we can sue them not only officially but individually. And when you sue someone individually, that means look, this isn't just taxpayers that are footing the bill here. This is potentially you personally are going to be held responsible. So, for example, Students for Life at Fresno State University. Fresno State actually had perfectly good policies. They didn't have speech zones at Fresno State. What happens, you had one particular professor, Professor Thatcher, who decided that he was going to organize a group of students from his class and that they would go out and erase the chalk messages from the pro-life group. And so you you actually see, you may have seen the video online that we have posted of that.
Yeah.
And then declare to the students that public universities are not free speech areas.
And that it was his free speech to stomp out their chalk.
That's exactly right. And so we've sued him both individually, or both officially in his official capacity as a professor at Fresno State, but also individually. And so he's potentially personally on the hook in that case. We think that there's clearly established law that says you cannot do this. And he knew and should have known that. So this isn't a simple mistake, misunderstanding. This is something that any government official should have known he was not in his right to do. So I think that there can be some impact from that. But, ultimately, I think this is a much bigger cultural problem than it is a legal problem. We have to restore a respect, which I'm grateful for the work that you all do in teaching students how to dialogue, because we have to restore a respect for that reasoned debate and have that replace the kind of vitriol that we're seeing on many campuses.
Well, we appreciate that, and we definitely want to discuss more of that kind of moral argument side of the free speech debate that's happening at a larger cultural level. But first, I want to give you another kind of more practical legal question, which is, sure. It seems like some cases where you've got individuals going after students' free speech, the university has like plausible deniability or something, where like you can't go after the university very effectively. What is the difference between a successful case where you can say, nope, this university / this individual definitely knew what they were doing, they shouldn't have done it, and now we can go after them in a way that's going to actually do something, versus them being able to say, well, we didn't really know what was going on, or there was a misunderstanding, like that kind of thing? Do students just need to bring their iPhones and videotape every conversation they have with the official? So if they say, oh, man, heckler's veto is totally legal, then you can punish them in court. Like what should students do to try to make sure that their cases don't end up in the pile of cases that just nothing gets done?
Sure. Well, so first of all, video and documentation is very helpful. The other thing I'd say, though, is contact us on the early side. So one of the things that we see is, frequently is people will often think, well, yeah, but you're the nonprofit legal organization, and I don't want to contact you early on. I want to play this out with my administrators first, and then if it really becomes a problem down the road, then I'll contact you. And what that often does is it puts a 19-year-old college student in a position where the general counsel for a university and the administrators from a university are figuring out how to respond best to some of their emails to put them in the best possible position they can be in if the student ends up wanting to sue the school. And so you have a situation that probably was something that the school was in a really bad position, and they're able to fix it over email. So if you contact us early, we can help you figure out, all right, look, if we have to have a little bit of information here, how do we want to phrase an email or phrase a question or whatever, so that we can get that answered without giving them the opportunity to sort of cover their tracks. So no, you're not paying me, but call me anyway. And let's see if we can figure out the best strategy. When you have a speech code or a speech zone issue or whatever it is on your campus that's causing you difficulties, let's work out a strategy on how to get that addressed, instead of students sort of trying to do it on their own and calling us after the fact. That often leads to the school having sort of fixed the problem or made it difficult to address the problem.
So it sounds like it'd be easier for you to do your job if students were quicker to call you and slower to be like, oh, I don't know, I don't want to bother them. Like their time's really valuable.
That is exactly right. Right.
Great.
Bother me more.
Students don't want to make a mountain out of a molehill, and they don't want to
Right.
bother you for nothing. So could you list some practical red flags? If this is happening, you should be giving us a call on the early end, versus
Sure.
something that, maybe that is a molehill and you don't really need to seek legal
Right.
counsel.
Sure. Well, first of all, I specialize in molehills. So that's, but really, I think this is, this is one of the things I think what I always tell students is you have on one side you have the left-wing students sort of going around finding a microaggression under every rock.
Right.
And, everything is a problem. And then you usually have the more conservative students who think more like that, who think, look, I don't want to create a problem here, who will say to us, I'm all about the First Amendment, I'm all about defending free speech. Right now, it's not a problem on my campus. I have to submit my flyers 2 weeks in advance to be able to get approval to hand them out. But so far, I've gotten approval, so it's not a problem. And what I would say is that is a microaggression against your First Amendment rights. It's actually a pretty macroaggression. And so, we're trying to encourage students to become more, get ready for this term, freedom woke.
Ooh, that's so good.
I thought you might appreciate that. So we're trying to encourage students to understand that, look, when you are being required to get prior permission from the government to speak, even if they're eventually granting you the permission, that's not okay. And it's not even so much about your free speech rights, because ultimately, yes, okay, you're just going to have to organize yourself better and get, figure out what I'm going to want to say 2 weeks from now. And there are all kinds of problems that can come with that. If the Supreme Court comes down with a decision tomorrow overturning Roe versus Wade, you don't want to not be able to talk about that for 2 weeks, but that's a whole other issue. The big problem is what that communicates to all these students around you. Because you respect the First Amendment more. You know that, well, this is a problem, but I'm not going to make an issue of it. Other people are learning that this is how this works, that the government is the grantor of First Amendment rights. And if they want to tell you what you can say, when you can say it, where you can say it, who you need permission from, that's a perfectly normal way of thinking. And they're not going to leave that on campus when they graduate. And so this is an educational thing as much as it is anything else. If you've got policies like that are saying for your student group, hey, we want to form a student organization, well, that's great. You have to submit it to this nameless organization that just will let you know at a later date whether you're approved. That's not okay. You can't have this sort of discretion for someone else to make that call, or where you're allowed to speak or who you need permission from. All those sorts of things are things that we would prefer to hear about. They don't all have to result in litigation. Many of these can be dealt with by letter. We solve a whole lot of problems by letter, but we'd prefer to solve the problems rather than just sort of let them sit out there until one day it is a problem for a pro-life group or someone else.
Casey, this has been really helpful. I want to ask you one more question before we let you go, and this is going to kind of shift us from the legal questions more to the moral. But this is also one of the more common things that I'm hearing from leftists when talking about why it's good to do things like block the Ben Shapiro event, which would be responding to the idea that it's understandable for protests to get loud and maybe even violent if they're opposing quote unquote dangerous speech like Nazism. So some say that a conservative speaker giving a talk opposed to same-sex marriage is basically threatening the lives and or livelihood of LGBT people. And so it's understandable for them to react violently. It kind of going back to that idea that microaggressions can be defended against with macroaggressions. Just what thoughts do you have about arguments like that before we let you go?
If we are confident in our ideas, then we should be perfectly comfortable with people opposing those ideas and knowing that we can win the day if we debate this out. And so to me, what it shows is a lot of weakness. It shows a lot of concern and a lot of fear that their ideas maybe aren't the best ideas. And I will say that, and then I'll also say for people on the right, we have to think in this, we have to look at ourselves in the same way. Are we looking at some of the, because you'll see idiot professor from whatever school has said something incredibly offensive. And the immediate calls, often even coming from the right, will be, well, this guy needs to be fired. I prefer to know who those idiot professors are. I want them to continue to speak, to say what they believe, because I want to know who those people are. And frankly, I want to know who the Nazis are too, because I want to know that, if the owner of that business over there, in fact, really is a white supremacist, that's something that I would like to know, so that I can, make my own spending choices wisely. So the First Amendment is very helpful for allowing people to communicate their own idiocy. And so that's, one critical reason we need it is for that reason. So, but it's not violence. Speech is not violence. And if it is, then that leads us to some very dark places. If we're really going to start treating words as violence, then it justifies any form of violence. And I don't really think that's what we want. So, but I think ultimately it's an expression of concern, of fear, that they're not going to win the day. If they thought that we can let the Brahms do their speaking and then we can just explain why they're wrong, then they would do that. What they fear is that people are going to be persuaded by those ideas, and so they can't let them be heard.
Right.
So I think it's basically just an expression of their own lack of confidence.
Casey Mattox serves as senior counsel and the director of the Center for Academic Freedom with Alliance Defending Freedom, or man who makes his living suing schools. I'm going to list all the contact info for ADF in the description below. Casey, thanks so much for joining us. This has been really helpful. Thanks, Casey.
Thank you. Appreciate it.